welcome you. This Knowledge is Power series is a series of three. This is the last one, actually, to talk about some of your rights while working. And so the other two recordings for the pieces of this series, job applications and interviews, and the negotiations, are on Career Services YouTube page. So specific to those topics, you can always access that information if you'll find it helpful. I am Cheryl Rotyliano. I'm the Interim Director of the Career Services Office at IC.
I am an Assistant Counsel in the Office of the General Counsel, where I handle all kinds of things, but some of that is employment matters. Before coming to Ithaca College, I worked for GST BOCES doing employment law and labor relations for 15 different school districts in the Southern Tier. And before that, I was in private practice as a labor and employment attorney and a litigator at Miller Mayer, which is in Ithaca. And it is so great to be able to share a brief overview of your employment protections with you guys. Please feel free to ask any questions.
All right, we're going to kick it off real quickly here with a poll. We are curious to hear what motivated you to attend today. What kinds of information are you looking for? That may help us be able to tailor some of what we talk about. So what we have here, general curiosity being the largest reported response, thinking about preparing for job searching, that makes sense, some internship searching, and then we have some others. If people want to share what their other response is, feel free to do it in the chat, but certainly not required. Thank you. Okay. So what we're going to do today, this is a general overview of some of the main topics, and then we'll dive in an overview of state and federal protections pertaining to employees in the workforce. So as I said, the other portions in this series have been specific to other sort of things along the timeline of job searching, of looking for internships, interviewing, and all of that stuff. Now we're going to talk specifically about while you are working, what are some of the things in place? Things like paid leave programs, wages, rights to concerted activity, and of course we're going to define what that is. And then we will finish by also talking about resources for some of the governing bodies in order to report discrimination if you do experience it.
There are a ton of different federal and state protections that protect your rights in the workplace. Some states are much more protective than others. New York and California come to mind. At the state level, they can vary quite a bit. There are some states that just rely on federal protections and don't have their own versus others, again, like New York and California. It's also really important to remember in this presentation, we're giving you an overview. We're speaking in generalities, and there are almost always exceptions to the things that we tell you. As I discussed with Cheryl, we could probably spend a whole year course talking about this stuff and not cover everything that you could possibly know about it. So just, we're flagging issues for you, and there's always more depth to the concepts we're covering. And just to make it real clear, the goal of this presentation is to empower you to ask questions, to flag issues for you, and to know when you should maybe go and ask somebody about your rights and your obligations in the workplace. We can't give you specifically tailored legal advice to individual situations. But what we can do and will do is just give you an overview of what the issues are so that you're empowered to go seek that legal advice should you need it later. Okay, so general overview of protections. The big one for employment discrimination is the Civil Rights Act of 1964, also known as Title VII. And Title VII applies to private and public employers, and it's unlawful for an employer to take tangible discriminatory action against an employee or subject an employee to a hostile work environment, both of which are very big terms that encompass a lot of things. And you can't take employment actions based on the following characteristics. these are the big ones: age, race, color, religion, sex, national origin, sexual orientation, gender identity, and transgender status. So the bottom three are actually components of sex discrimination. The Supreme Court held last summer in Bostock versus Clay County, Georgia, that firing individuals because of sexual orientation or transgender status violates Title VII's prohibition on discrimination because of sex. So that is a federal protection that you have. Also keep in mind state law protections. In New York State, race is defined to include hair texture and protective hairstyles such as braids, locks, and twists. And that protection from discrimination based on natural hair is gaining traction in other places. You can expect other similar protections to come into place later. And also, I've covered this in previous presentations for those of you who have come to those, but it's very important to realize that something you don't see on here protected at the federal level is criminal history. Under federal law, employers aren't prohibited from asking about your arrest or your conviction records. Some state and local laws do forbid that, and there's a push to move towards that in a lot of jurisdictions. So just be sure, if that's a concern for you, to check the jurisdiction to which you're applying. New York State bans inquiries about prior arrest records that are not currently pending or have been resolved in favor of the individual, which means if you did not get convicted or you got a youthful offender adjudication or a sealed conviction, they can't ask. Pending arrest or criminal accusation is not protected. And there are some exceptions to the ban the box legislation, such as if you're going to be employed as a police officer or if there's a direct relationship or an unreasonable risk. So again, if that's a concern for you, definitely check your jurisdiction and maybe seek some legal advice on what the law is in the jurisdiction to which you're applying. Next slide. So tangible employment actions. Those are the more obvious ones that come up in discrimination cases. And those are a significant change in your employment status, right? So hiring, firing, promotion, demotion, undesirable reassignment, or a decision causing a significant change in your benefits, compensation decisions, and your work assignment. So for instance, if you had been full-time benefits eligible and you complain about discriminatory activity, and then the next week you are put on a part-time schedule and you don't get benefits anymore, that's something that starts to look like a tangible employment action. Or if in your department, say you're female and male colleagues get promotions consistently and female colleagues don't, that starts to look like tangible employment action discrimination as well. And the other type of employment discrimination that comes up a lot is hostile work environment. So hostile work environment is where harassing or discriminatory conduct creates an environment that would be intimidating, threatening, or hostile to reasonable people. That standard is different at the federal level and some state levels. New York State, for example, changed its threshold from the federal severe and pervasive standard to being treated less well at work because of a protected characteristic. But if your work environment is feeling like a stressful place to go because somebody's treating you differently based on a protected characteristic, that's a pretty good flag that you should report or go seek some advice about your rights in the workplace. Moving on. Some other federal protections just to be aware of that apply are the Americans with Disabilities Act, which is a big one in the employment context. The employer is required, if they hire a person with a disability, to provide reasonable accommodation to allow that person to do their job, along with an interactive process that can lead to that reasonable accommodation. The Genetic Information Non-Discrimination Act is just something to be aware of. It prevents genetic testing of individuals or making decisions based on things like family medical history. And the Immigration Reform and Control Act prohibits discrimination based on citizenship in most employment contexts. the Age Discrimination in Employment Act is also an important protection that probably doesn't apply to this group, but is something to be aware of as well. So dress codes are something that come up a great deal when talking about discrimination in the employment context and your rights at work. Dress codes generally can't treat some employees less favorably than others because of national origin, right? So if you say you can't wear a sari to work, but otherwise allow people to wear, say, dresses. If a dress code conflicts with the employee's religious practices and the employee requests an accommodation, the employer is obligated to modify the dress code or permit an exception, unless doing so would result in undue hardship. There was a big case involving Abercrombie and Fitch where they had an employee who was Muslim and wore a hijab. And she was told that it didn't comport with Abercrombie's look. So she refused to not wear her hijab and was fired. And the courts held that Abercrombie's assertion of the look policy did not constitute an undue hardship for allowing somebody to wear a head covering at work. Similarly, if somebody requests an accommodation to a dress code because of a disability, the employer has to modify the dress code or permit an exception, unless doing so would result in undue hardship. And undue hardship is pretty difficult to prove in this context. Employers can adopt dress and grooming standards that are applicable to everyone and require, for instance, that your hair be neat, but they can't tell you to necessarily wear your hair at a certain length, right? Because that can discriminate between male and female employees. Courts have only indicated that it may be discriminatory if there's no business justification for the policy. If the employees aren't public facing, the policies are particularly difficult to justify, right? If you're a receptionist and there are rules about how much jewelry you can wear, right? As long as that's applied pretty generally across genders, the employer's not going to get in trouble. But if you're being held to a different standard than somebody of a different gender, it might be time to ask questions about it. Another, sorry, go ahead.
We did get a question in the chat. What does undue hardship refer to?
Good question. And that is one that lawyers struggle with quite a bit. So undue hardship often is expense, or if you risk losing a lot of business as a result. It often comes up in the disability context. If somebody needs a modification to do their job that just the employer can't really afford to do, or if the accommodation would not permit work to get done. This has been applied a lot of times with absenteeism. So if an employee has a disability and the accommodation they want is to work from home, but say their job requires somebody to be on site, that could be an undue hardship for the employer because they need somebody on premises to do that work. This is an essential function of their job. Similarly, if sometimes somebody doing a difficult manual labor job can't lift over a certain amount. So if you have somebody whose job requires them to pick up heavy boxes and lift them over their head, if they say the accommodation is, well, I want somebody else to help me lift those boxes, then if the employer can show that taking somebody else away from other duties to help this employee do that part of their job is going to cost them like double what it would to have that employee do that essential function themselves, then they have a shot at proving an undue hardship. But it's fact specific and tricky. But again, with dress codes, if you are differentiating based on protected characteristics, you're very unlikely to show undue hardship. Any other questions in the chat that I missed because I wasn't looking at the chat?
That's it so far. Yeah, I'm on it.
Okay, cool.
No worries.
Another thing that comes up in the workplace quite a bit is protected concerted activity. And this shows up a lot in employee handbooks. The NLRB has put out an extensive summary of decisions about employee handbook provisions. And surprisingly, Section 7 of the National Labor Relations Act protects certain actions by workers, whether or not they're in a union. People are often surprised that the National Labor Relations Board has jurisdiction over employers where their employees aren't unionized, but they do. And they protect discussion amongst employees of the terms and conditions of employment and their working conditions. This has been held to extend to social media in a lot of ways. Social media has been termed by the NLRB to be the modern equivalent of a water cooler. So if you are complaining about work to your fellow employees on social media, that's probably protected. And the NLRB has found like egregious cases of very foul language toward employers in a public forum to be protected. The Trump administration has sort of gone the other way on that, but you would be shocked at the kind of things that the NLRB has found you can say about your employer to your coworkers on social media. That is not an endorsement of that behavior, it's just something to be aware of. And you have the right to complain about your working conditions, which can be related to OSHA, which is a federal law saying that your employer has to provide a workplace free of hazards. But it doesn't have to be. It can be like, wow, my boss did something that was really mean and I didn't like that. How do you feel about it, coworker? Like, that is protected. And when you're thinking about this kind of stuff, I mean, I have to think about the edge cases and the crazy stuff because of my job. You guys probably don't have to do that, but it is good when you go to work at a new place to read the employee handbook and see what the culture is and what the expectations are. I think we have a poll.
Indeed. All right, here we go. So we talked a little bit about social media, talked about some scenarios. This is an anonymous poll, so we're curious since this is a topic that comes up a lot. Are you permitted to ask your colleagues about their salaries? Still waiting for some votes.
Yeah, it's anonymous and we can't see who voted what, so just take a stab.
No need to Google to answer this poll.
Not being graded.
Okay. All right, I'll close it out. We've got, let me share. We've got quite an even distribution here between, I'm not sure, yes, and no.
And it totally makes sense that you're not sure because there is this cultural, pervasive statement that goes around that it's illegal to ask your coworkers about their salaries. It is absolutely not. In fact, that is a right that's protected under Section 7. They don't have to tell you, but you are permitted to ask and to discuss your salaries with your coworkers. And I'll hand it over to Cheryl.
Yeah, and so to break this down just a little bit, and of course we're kind of switching between when we talk about some details in some areas and then when we zoom out a little bit to what this may mean for you. or for people in general. So basically what we want to emphasize here is that these protections are to keep employers, to prohibit employers from being able to use criteria when they are making decisions, any sort of action, as well as, since we're talking about the workplace, treatment as well. And so we'll talk a little bit, which can be an area of interest for people who have not had exposure to paid leave programs before. So we're going to go through a few of the ones that exist. Certainly, this is not to mean in any way, shape, or form that this is a comprehensive list. However, these are some of the ones where sometimes common life circumstances will, you know, allow you to use these programs. So as Emily talked about with the ADA, the Americans with Disabilities Act, sometimes those accommodations can be more frequent, right? There's a whole different sector of those that's about job responsibilities and adjustments made to those job responsibilities. Somewhat less commonly, but worth noting, is leave can be an accommodation for particular medical treatments. We've included some examples here on this slide. And then to give some other examples, FMLA can be used for serious health conditions, which can include pregnancy, birth, care for another person, which there are specific guidelines as to who that could be. And typically that is going to be 12 weeks unpaid per 12-month period. There's going to be different structures to how these programs work. It can, depending on which program exactly we're talking about, can vary by employer. And so really will be required, if you're in need of a leave program, required to do some research as well as talk to a human resources office within the employer that you're working in. So it's kind of a combination of those two things to truly be able to advocate for yourself. Workers' compensation being a program that is in place for work-related illnesses or injuries that occur. And then diving in even further here, and this is where we start to see some variances by states also. So that will make a big difference. Just like any, many laws and regulations, right, are state-based. So specific to New York State, there is paid family leave. Also can vary by state and also employer are COVID-specific regulations. I can't keep track of how quickly those change. So those can be a little bit tricky. And of course, you all are not quite in the workforce yet. And so they are likely to be adjusting and changing as time passes. Unemployment insurance is the other one that sometimes can be helpful to know about in advance, which involves involuntary job loss due to no fault of the employee. And that does vary by state as well. So that was a ton of, semi-detailed information about some leave programs that exist, some at the federal level, some at the state level.
So talking about OSHA, which I briefly referenced earlier, OSHA is a federal law that says every employer has a general duty to furnish a place of employment that is free from recognized hazards. And that means all kinds of things. It's come up a lot, obviously, in the COVID-19 era. There are federal and state guidelines that apply to employers. It talks a lot about things like ladders and hazardous chemicals, and requires the provision of personal protective equipment for tasks that require it. You have to have guardrails in your stairways. You have to have free and unobstructed exits. You have to have medical first aid supplies available, emergency action plans, and exposure control plan for bloodborne pathogens, which is especially important in the healthcare context. if you feel, they also have an obligation to report accidents. So you will probably undergo a training at some point with, what to do if there's an accident at work. And it's also good to know, if you don't have that training, hey, if something happens at work and I get hurt, who do I talk to? Or if there's something I see that's unsafe, who do I talk to? Again, looking in the policy manual is probably a good start. Talking to your supervisor if you're not sure what to do is also a good start. And that's just something to be aware of. If you're at a desk job, OSHA is less of a big deal than if you're a construction worker, but it's good to be aware of.
Yeah, and I would add, being open to asking questions about some of these things is okay. When I entered the workforce, I distinctly remember, especially at one place, having significant concerns in some of these areas, but feeling very uncomfortable about asking. And so these things are sort of in place for a reason. Personally, mine was exposure control plan for bloodborne pathogens. I wasn't in a healthcare context, but I was in sort of a social services context, and there were definitely things that happened that I was unsure of. Is this okay? And so wanted to encourage everybody to feel empowered to ask if there are things that in your gut might not feel quite right, that it is okay to bring it up as a question.
And we just wanted to throw in here some general work protections. One of them is breaks. There's no federal right to a lunch break, but in New York State, there's a very strong right to a lunch break. It requires a 30-minute meal break between 11 and 1 for employees who are working at least 6 consecutive hours. And under the law, employees can't opt out of that. Now, it is also important that you know that like a lot of people don't pay attention to this and prefer to work through their lunch break or eat at their desk or whatever. But you are entitled to at least a 30-minute meal break, even if you're salaried, if you're working at least 6 hours a day. And your employer's, what's probably going to happen is your employer is going to do one of two things. They're either going to tell you get lunch break and just like let you be and let you do whatever you want, or they're going to tell you that you get your lunch break, and if you try to skip it, they're going to make you take lunch. So just be aware that that's out there. Be aware that the employer is exposed if you don't take your lunch break. And if you have to go to the post office, definitely have that 30 minutes in your day to do that.
Yes, and so kind of zooming out a little bit again, I'm going to put a question in the chat that I want everybody to think about and then respond in the chat. So in thinking about what we've covered so far, thinking about some of these, the graph of protected characteristics that we've covered, what that means in terms of employers being able to either take action or have it affect treatment, thinking about leave programs, dress codes, right? So those are some of the things we covered. What do you think right now, in reflecting on some of that information, what do you need to know more about in order to either begin in the workplace or have this information be useful to you?
So Sean, I'm going to put a link in the chat for you that might be helpful, because there is quite a bit, but the NLRB has good resources on that.
Yeah, so a couple of responses about dress codes, which yes is, I mean, it's an interesting thing to navigate from any lens, right? In starting in the workforce and what am I supposed to wear? Even, not even thinking about discrimination and protected characteristics. So it's understandable that that's something that people are thinking about. Mhm. How managers and bosses are allowed to treat you as a person, and how far or when to know if something is either illegal or inappropriate. And we also see sexual harassment laws in the workplace.
I'm going to put a useful resource on dress codes up there too. This is from the Society for Human Resources Management, and it's geared toward HR officials, but it's kind of good to know what that society is telling HR people about what they can and can't do with dress codes. So I'm popping that in the chat too.
Yeah, and we can certainly come back to some of these things also. I think it's, I think it's important with any of this kind of information, especially because this is nuanced and there's so much detail and differences with states and all the things involved in this information, to kind of assess what else you want to know about and create some next steps for yourself. It will be an important part of this that will make it the most useful. So thank you for participating. And if we can address any of those things, we'll just go through the last couple slides, and then maybe we can circle back. All right. And so wanted to finish up here with what is important information about, we've talked so far in regard to wanting to educate and be able to advocate via, right, like knowing the information, knowing some of the protections that are in place. However, if someone experiences discrimination, right, if you believe it has happened, what do you do? And so this is a really, really super brief, of course, overview of what can exist to be able to help. We covered what we did because the regulations, laws, and all of that are really in place to protect you. What it means to have those things in place and why it's important to talk about retaliation is because, as Emily talked briefly about, an employer cannot take adverse or negative action in response to a claim that is made, which does also include former employees. So as an example, a claim was made, regardless of the outcome, someone giving a poor reference because of that claim that was made. And so what a lot of times may happen is, someone may decide to leave a workplace voluntarily because it's not working, right? And it just might not be an environment that is good for anyone. However, the employer on their end cannot take the adverse action themselves. So wanted to make sure we said that because it's a little bit, and the hope is that if you feel like if someone has felt discriminated against, there is some protection in place to not have a negative impact in your direction. Enforcement bodies exist, and I'll go over what those are. Enforcement bodies exist to help people report discrimination claims, investigate charges, recommend remedies, and in some cases, mediate disputes between people. I can't remember, Emily, was this your slide or mine?
This is my slide. I'm sorry, I had to catch up. So as we sort of referred earlier, the National Labor Relations Act protects concerted activities. So efforts to better your wages, your hours, your working conditions, including your right to self-organize by forming or joining a union. If you are in a union, it's really, really, really important that you know your union resources, because you can't then directly talk to your employer. You have to go through your union, and you'll want to go to your steward if you have an issue or want to talk about something. Not all employers fall under the NLRA, but most of them do. So protected concerted activity is something that you get almost everywhere. And then during the process of bringing a complaint or thinking about even an adverse experience at work, you definitely want to follow a formal process if your employer has one. If you've got a sexual harassment complaint, you want to follow the complaint process. You want to report to the appropriate people. You want to keep records. If somebody says something to you, make a note of it that day. If there's an email communication that you find problematic, preserve that email. And finally, know your rights. Know that you have the right to a workplace without discrimination and without being subjected to a hostile work environment, or know that you have the right to a safe workspace, or to talk about your working conditions with your colleagues. It's also just on a practical level, when you are thinking about bringing a discrimination complaint or any similar kind of workplace complaint, to seek support and to take care of yourself when you're following the processes, because it's just really difficult and emotionally draining to be working somewhere when you're dealing with the kind of adverse experiences that we're talking about. So make sure you're taking care of yourself. If you have paid time off that you need to take that time off. Find a counselor that you like to talk to about this kind of stuff. Go seek legal advice. Do what you need to do to feel supported. We just did a training. We had a training that we have to do for the college on Title IX and discrimination issues. And it was a really well put together training, but they were really emphasizing that when you're experiencing even things that don't rise to the level of the legal, right? Microaggressions, for instance, it can make it really difficult to do the work that you were hired to do when you're subjected to just emotionally difficult things day after day after day. So taking care of yourself is priority number one. Resources, turning it back over to Cheryl.
All right, so as promised, I'll get to these entities. The EEOC, the U.S. Equal Employment Opportunity Commission, is a lot to say, but a really helpful place. You'll see I took a screenshot of what their website looks like. So there's a ton of resources, and Emily put some of them in the chat also. So you can do some research on this website. And I took a screenshot of this filing a charge of discrimination, which potentially could be your first step in terms of getting some information, some advocacy, and kind of reaching out to them to let them know what's happened, right, in terms of a next step. Another spot, the Americans with Disabilities website, ada.gov. Is another spot where you can file an ADA claim. And then a local resource, actually, so a really accessible resource is the Tompkins County Workers Center. So you can see that they do have an email address. They also have a hotline, so can be a good spot also to just be able to get some thoughts, explain a little bit. They'll be, potentially more accessible, more contactable for just, wanting to get initial thoughts about something. And they, of course, will refer you potentially to some of the others that we talked about also.